We're with David Shapiro. David is a San Diego DUI lawyer, and he's agreed to answer some online questions that were posted to DUI in San Diego. With that said, David, let's get into the first question. It's from Janice. Janice says, I am facing my first DUI charge. If I plead guilty, what kind of sentence am I looking at?
Well, Janice, assuming your first DUI charge is a misdemeanor DUI without injury, the standard terms in San Diego County for a DUI conviction are the following. We place on probation for 5 years. That's summary probation to the court, no probation officer, nothing like that. Your fine would be just over $2,000. You would need to enroll in and complete either a 3-month or a 9-month first conviction DUI program, depending on your blood alcohol level. If it's 0.20 or above, it'll be the 9-month program. If it's 0.19 or below, it'll be the 3-month program. You'll need to enroll in and complete one Mothers Against Drunk Driving meeting. You would need to do something known as a substance abuse and assessment unit evaluation, possibly depending where in San Diego your case is going to be heard. And then depending on your blood alcohol level, if there was an accident, that type of stuff, some public work service may be in play. You're looking at additional license suspension if you're convicted in court of a DUI. Under law, you could get up to 180 days in jail for a first-time misdemeanor DUI. Realistically, unless there's really unique circumstances, you should be able to get out of this without having to go back to jail. But nothing obviously is guaranteed until we review the facts of your specific case.
All right. Next question was from Howard. He says, I was charged with DUI after an accident. The only injury was to my brother, who was a passenger in my car. Am I facing additional penalties because of this?
Well, Howard, you definitely could. I think at the very least, since someone other than yourself was injured, in this case your brother, who you're saying is a passenger, you're likely facing DUI with injury charges under Vehicle Code Section 23153. That could be filed as a misdemeanor or as a felony, and a lot will depend on that, whether or not your blood alcohol level can be proven to be a certain level or not. If you're at a really high blood alcohol level, that's pushing you closer to running the risk of being charged with a felony. If your brother was injured and if there were injuries more than just normal scrapes and bumps and bruises, that's something that's pushing it more towards a felony. If your brother was seriously injured, that's something that would certainly push it towards a felony with a great bodily injury enhancement, where you could technically be facing up to 6 years in state prison and facing a strike felony charge. So there's a lot of variables that go into it.
Okay, next question was from Linda. If I'm arrested for DUI, if I am arrested for DUI and there was a child in the car, what additional charges am I facing?
Well, Linda, there's a couple of things. First, you could be facing entirely new child endangerment charges. Okay, so a lot of times we see if there's a child in a vehicle, you'll be charged with your DUI charges, and then the next count, usually count 3 or count 4, would be a child endangerment charge for each child that was actually in the vehicle. Those can be filed as a misdemeanor or as a felony, have their own penalties and consequences. Sometimes what we see, though, is the district attorney or the city attorney, the prosecutor, will file your DUI charges, and then we'll add an allegation attached to that charge saying that there's a child, usually if the child is under 14 years of age, in the vehicle. That in and of itself could add mandatory jail time, additional jail time on top of what you may already have received. So it could be filed 2 different ways. In those cases, I can tell you from experience, are certainly prosecuted more strictly and more heavily than your standard DUI without a child in the car.
All right. Second to last question was from Fred. Fred says, I've been charged with DUI drugs. There were no chemical tests performed, but the police officer says he could tell by looking in my eyes that I was under the influence of drugs. Can I be convicted on this conclusion?
Well, Fred, it looks like I think you've been arrested on that conclusion, but I don't think you'll be convicted on that conclusion without an actual blood test or your analysis looking at what, in fact, was in your system. You know, like anything else, if the allegation is that you were under the influence of a controlled substance or marijuana or whatever it is, without knowing whether, in fact, that substance was, in fact, in your blood at the time driving, let alone to what effect it impaired your ability to safely operate the vehicle, you know, they're going to have a real tough time. It's unfortunate you got arrested based on that, but without a chemical test, without, you know, blood work, without some type of analysis of what, if anything, was in your system at the time driving, they're going to have a hard time proving that. certainly as it relates to driving a motor vehicle under the influence of a controlled substance or of alcohol or of marijuana.
Okay, excellent. And the final question we had was from Billy, and this was, I was arrested for DUI. I had one drink 45 minutes prior to getting behind the wheel. The breathalyzer said my BAC was 0.26. How can I prove the breathalyzer was wrong or defective?
Well, yeah, one drink is not going to get you to a 0.26. It might get you to a 0.026, Billy, but it's not going to get you to a 0.26. So what I would look at if I were you is this. Well, first off, you don't want to omit too many case-specific facts on, questions that might go on videos and that type of stuff. So the first thing is, though, what I would do and what you should do is get a list of the names of anyone and everyone who was with you that entire day through the night. Ideally, you are around people who will come off as credible, who could say, hey, I was with Billy that night. He only had one drink. I was with him for the last 3 hours before he drove, to cast doubt on the validity of the machine, of the breath testing instrument. Okay, if everything went as you're saying, then there may be a big issue, and there's definitely an issue with how that chemical test, whether it was administered improperly or whether the machine itself was failing. Breath tests are a lot more difficult in the last couple of years to try and attack the validity of it if it meets certain criteria. But there's always doubt as it relates to that. And the goal would be, if the case proceeds to trial, is you want to put people on that jury, if possible, who are not dependent on machines in their everyday life and who might be skeptical of machines, especially dealing with the weight of the evidence that we would be able to present that you only had one drink, as you say you did.
Excellent. Well, if you have any other questions for David, just post them in the comments section below. He's agreed to answer your questions directly online. Thanks for your time, David.
My pleasure. Again, I can be reached 619-295-3555. Thank you.